Good afternoon. I'm Leona Jochnowitz, and this is a lecture for the Legal Studies research class on the topic of intellectual disability and the death penalty. I will present a literature review of the evolution of the cases from 1989 until 2017 in the form of 5 cases. These cases begin with Penry versus Leona, where intellectual disability was just one factor and not an exemption from execution. Atkins versus Virginia in 2002, where the court prohibited the execution of ID disabled persons because they were categorically less culpable than the average criminal. Hall versus Florida in 2014, where the court addressed the bright line cutoff rule of a rigid score of 70 because intellectual disability is a condition and not a number. Brumfeld versus Kane in 2015, where the court addressed defendants' ability to plan the crime as just one factor, but not precluding a diagnosis of intellectual disability. And finally, Moore versus Texas, where the court refuted stereotype lay definitions of intellectual disability because they created an unacceptable risk that persons with ID will be executed. This lecture focuses on the proportionality of punishment. Intellectually disabled persons are not culpable for the harshest punishment. The Eighth Amendment prohibits cruel and unusual punishment based on a test of the evolving standards of decency that mark the progress of a maturing society. This lecture shows how the punishment of intellectually disabled persons has evolved based on a growing national and international consensus. In fact, after Atkins, very few persons with intellectual disability had their convictions reversed. But the evolution of these principles show that courts have given the states now guidelines how to make the decision of defining intellectual disability. In Penry versus Leona in 1989, the prevailing rule was that intellectually disabled offenders were not categorically excluded from the death penalty. ID was just one mitigating factor that capital jurors could consider in weighing an offender's culpability for harsh punishment. Penry was a Texas case where one of the considerations was future dangerousness, and prosecutors like to use the disability of intellectual disability to show that the defendant would commit acts of violence in the future. Therefore, ID was double-edged. It was both aggravating and mitigating. The Supreme Court told the states that they must develop standards to guide jurors to consider and give effect to ID specifically as a mitigating factor and not a double-edged aggravating factor. In Atkins versus Virginia, that case overruled Penry. The Supreme Court prohibited the execution of intellectually disabled persons based on a growing national consensus that intellectually disabled defendants were categorically less culpable than the average criminal. Why were they less culpable? They had diminished capacities to understand and process information, to communicate, to abstract from mistakes, and to learn from experience, to engage in logical reasoning and have impulse control. This did not make them morally inferior, but simply more impulsive. Executing a person with ID served no penological purpose of deterrence or retribution. It weakened the integrity of the judicial system and encouraged wrongful convictions because persons with ID gave false confessions, they could not confer with counsel, and they were unable to testify on their own behalf. However, in Atkins, the court found that while there was a national consensus against the execution of persons with ID, there was serious disagreement over who was intellectually disabled, and it left to the states the job of identifying and defining these protected persons. The rest of this lecture will demonstrate the evolution of law into who is intellectually disabled. In 2014, the US Supreme Court ruled on an important issue in Hall versus Florida, where it overturned the bright line cutoff rule in 9 states, holding that rule that strictly identified intellectual disability as numerical IQ under 70 was invalid. In fact, the court found that the test should employ the standard error of measurement, the SEM, a range of scores rather than a fixed number of 66 to 76. That resolved the issue of whether somebody could be executed with an IQ of 71, but not an IQ of 69. And the court also permitted information regarding the defendant's social and cultural adaptive functioning. Disability was a condition and not a number. In 2015, the court went on in Brumfield versus Kane to look at the issue of defendant's advanced planning of a crime. In that case, the defendant had acquired a car and weapons. And the court held that neither the defendant's ability to plan the crime or the presence of a personality disorder precluded a diagnosis of intellectual disability, because these persons may have strengths in some areas and overall limitations in other areas. And therefore, the planning of the crime was not definitive. Further, if the defendant was diagnosed with antisocial personality disorder, that did not mean he was not intellectually disabled, because intellectually disabled persons have trouble learning from their mistakes and can be misdiagnosed with antisocial personality disorder. The final case we will discuss is Moore versus Texas. In that case, the defendant had an IQ of 74, which the court appropriately under Hall adjusted for the standard error of measurement to be a range of 69 to 79, and therefore numerically he was intellectually disabled. However, the court used lay testimony from family, friends, and teachers to show that despite this numerical measurement, that his adaptive behavior did not amount to intellectual disability. What were those adaptive behaviors? He basically, although at age 13, he could not identify the days of the week, he dropped out of school, he lived on the streets. Nevertheless, he had the ability to commit the crime in a sophisticated way, and he was living on the streets. The court ruled in that case that anything except for medical clinical standards would not be acceptable in establishing adaptive functioning, and that lay stereotypes of the intellectually disabled would lead to the risk of executing persons with mild intellectual disability. Secondly, the court held that persons with comorbid traumatic experiences like child abuse were risk factors and were not inconsistent with low adaptive functioning. In conclusion, the Eighth Amendment principle preventing cruel and unusual punishments is based on the evolving standards of decency that mark the progress of a maturing society. We have shown here that only small numbers of offenders sentenced to death at the time of Atkins had their death sentences commuted because of confusion in the states about the definition of intellectual disability. But the punishment of persons with ID has evolved based on a growing national and international consensus. And the cases that we have shown continue to give direction to the states. First, in Penry versus Linnau, ID was just considered one mitigating factor against death sentencing. But in Atkins, the court ruled that persons with ID were categorically less culpable than the average criminal. In Hall, the court found that the bright line cutoff rule of a rigid IQ score of 70 without adaptive functioning was an inappropriate measurement. In Brumfield versus Kane, the court found that defendants' ability to plan the crime or the existence of personality disorders did not preclude a diagnosis of intellectual disability. And finally, in Moore versus Texas, the court ruled that only clinical definitions of intellectual disability could avoid stereotyping and the risk of executing mildly intellectually disabled persons. That's the end of this lecture, and thank you very much.